The topic is main provisions of the Banking Companies Act or Banking Regulation Act 1949. Guys, in order that a bank may be a banking company, it is necessary that it must be a company, first of all, established under the Act of 1949. A bank established by central government in accordance with the provision of any other act is not a banking company, as is held by the Supreme Court in State Bank of Travancore versus Muhammad M. Khan, AIR 1981. What are the objectives of particular Banking Regulation Act 1949? The act was needed for number one, checking the abuse of powers by persons who control some banks, and number two, the absence of measures for safeguarding the depositors of the banking companies and the country's economic interest in general. Number three, the act provided a machinery by which proceedings in liquidation of banking company could be expedited and speedily terminated. This view was affirmed in Dhirendra Chandra Pal versus Associated Bank of Tripura, AIR 1955. So what are the main provision of Banking Regulation Act 1949? The Act contains the provision for regulating the functioning of the Indian banking companies and corporation. The Act contains the provision for regulating the functioning of the Indian banking companies and corporations. The provision except Section 56 apply to all banking companies which are not nationalized. However, some of the provisions apply to nationalized banks also. So the main provisions are number one, banking company and the form of business in which banking company may engage are expressly defined in Section 5, 5C and 6 of the Act respectively. That means the term banking has been defined in Section 5, banking company has been defined in Section 5 Clause C, and the form of business in which banking company may engage are defined in Section 6 of the Act. Banking company means a company engaged in banking business in India, and banking means the accepting for the purpose of lending or investment of deposits of money from the public, repayable on demand or otherwise, and withdrawable by check, draft order or otherwise. Number two, the Act does not apply to those cooperative banks which have paid up share capital and reserves of the value of less than 1 lakh. Number three, the Act provides the requirement of aggregate value of the paid up capital and reserve of all banking companies in India or outside India separately. The Act provides that the requirement of aggregate value of the paid up capital and reserves of all banking companies in India separately and outside India separately. So Section 10 of the Act provides for directors, managing agents, chairmen and their powers amply to check unhealthy manipulation between two or more banks. Number 5. The Act by its Section 10A, 10B, 10BB, 10C imposes social control on all banking companies other than the SBI and 20 nationalized banks. Number 6. Shareholders' voting right is kept limited for restraining control over the management of preferential right on assets of the banking companies. Shareholders' voting right is kept limited for restraining control over the management of preferential right on assets of the banking company. Number 7. Restriction on loans and advances to be granted by the banking companies are imposed by Section 10 of the Act. Number 8. The Act provides that the rate of interest charged by banking companies shall not be subject to scrutiny of courts, but that means it is not the matter of court to decide the rate of interest which would be charged by a banking company. It is not the business of the court, it is the business of the banking company itself. Number 9. Section 21 of the Act lays down the Reserve Bank's power to control advances by the banking companies. The circular issued by the RBI under Section 21 or 25 are statutory and binding on banks. It was decided in Canara Bank case AIR 1908. Number 10. The provisions as to licensing of banking companies are given in Section 22, and as to restrictions on opening or transfer of their branches are provided in Section 23. So, RBI would provide license to the banking company. It is defined in Section 22, and if there is a restriction, if we talk about the opening of branches, it is mentioned under Section 23. 11. The Act provides for maintaining reserve fund, cash reserves, etc. distinctly by the banking companies. 12. The provision regarding maintenance of a percentage of liquid assets in different forms are given in section 24. That means what would be the percentage of maintaining the liquid asset? It is enumerated in section 24 of the Act. 13. All banking companies are required to submit monthly and other returns to the Reserve Bank of India. 14. The Act contains the provision regarding audit, inspection, suspension of business. Suspension of business is termed as moratorium, winding up of amalgamation of a banking company. 15. The central government is empowered by the Act under its section 36AE to 36AJ to acquire a banking company in given circumstances and to make rules etc. for them. So central government has been given power under section 36AE and 36AJ to acquire any banking company. There would be some circumstances which must be there in order to legitimate acquisition of the banking company. Number 16. In order to prohibit bank employees demonstrations, strikes, etc., the Act provides punishment for certain activities, and the Reserve Bank has been empowered to impose penalty on banking companies in case of contravention or defaults in their acts. So for the purpose that the banking employee, the employees which engage in a banking business should not strike, there are some punishment has been enumerated in the Act itself for prohibition of such kind of activities. So we are talking about 17, the number 17 point. Part 2 of the Act contains provision as to its applicability to certain cooperative banks. 18. Section 35A is added to implement the Banking Ombudsman Scheme 1955 to redress customer grievances against commercial banks except regional rural bank. That means whatever the grievances against the regional rural bank would not be addressed, would not be considered under particularly this scheme, Ombudsman Scheme of 1955. And scheduled cooperative bank, that means if any customer is aggrieved against the activities of the banker named as commercial bank and scheduled cooperative bank, it can go and complain in Banking Ombudsman. Banks Ombudsman, which is established, would be established in the major cities under Banking Ombudsman Scheme 1955. So 19. Section 45 of the Act provides the scheme of amalgamation of banks. What would be the provision, what would be the procedure followed in case of amalgamation of banks? It is enumerated in Section 45 of the Act. Thus the Act 10 of 1949 is a landmark in the history of Indian banking companies.